All right, good afternoon for those of you on the East Coast. Welcome to PilieroMazza Annual Review, what DOJ's 2024 FCA report means for government contractors. If you are a repeat listener, Jackie and I do this webinar each year to talk about DOJ's annual report on fraud and False Claims Act recoveries. And so we've got some insights from this year's report, and there's some interesting things going on in the FCA outside the report. So we appreciate you for having joined us, and please feel free to ask questions throughout or ask for clarification if there's anything you have questions about. So we'll go through a quick introduction. My name is Matt Feinberg. I'm a partner and the chair of our False Claims Act practice group here at PilieroMazza. I represent government contractors and businesses that are involved at least tangentially with government contractors in False Claims Act litigation, investigations, and I also do risk management from a False Claims Act perspective. And I'll let Jackie introduce herself. She's my co-chair.
Thanks, Matt. Hi, everyone. I'm Jackie Unger. I'm a partner here and chair of PilieroMazza's Government Contracts Practice Group and also co-chair of the firm's False Claims Act group. In my practice, I help contractors navigate pretty much all aspects of doing business with the federal government, from helping them through False Claims Act investigations to counseling on FAR and small business regulatory compliance issues and litigating bid protests. It's just a few of the things that I work on.
Sure. So a quick disclaimer before we get started on the content. Our webinar today is not intended as legal advice for any particular company or person. We are providing our insights, opinions, and thoughts on what might happen in the future and what is going on perhaps this year based on information from the report. But nothing that we say today is intended to create an attorney-client relationship. There's no attorney-client privilege that applies to what we're saying today, and we can't guarantee that what we're saying today applies to your specific situation. So if you have specific questions about an FCA investigation, FCA compliance, or FCA litigation, I would encourage you to reach out to me or to Jackie or to someone else on our False Claims Act team separately so that we can address your specific provision or situation rather than using generalities. Another quick thing I want to mention is that if you've been to Jackie and my webinars before, we're not going to do a deep dive on the background of the False Claims Act. There are other webinars that are available from PilieroMazza that do those deep dives and explain exactly what the False Claims Act is and what it means. We're going to skim through that here because we're really focusing on the report itself and the takeaways from that report. But if you're interested in hearing more about the False Claims Act or the things that we offer at PilieroMazza, please check out our other webinars and they'll give you sufficient background to understand everything we're talking about today. All right, let's move on.
Okay, so before we jump in, I just want to give a brief overview of what we're going to touch on today. So we're going to briefly talk about background on the False Claims Act and provide some examples of types of False Claims Act liability, as Matt said, at a very high level. Then we'll dive into DOJ's annual report and what we're seeing there in terms of new FCA matters and that they're continuing to increase. We'll touch on the settlements and the judgments that we're seeing, which remain high. We'll talk a little bit about the different types of settlements that we're seeing with a focus on healthcare fraud, procurement fraud, pandemic fraud, and cybersecurity recovery. And then we'll wrap up by talking about some False Claims Act litigation in the courts and where that stands. Okay, so jumping right in, we do want to give a brief high-level overview of the False Claims Act. So at a high level, the FCA is a statute that imposes liability on anyone who submits a claim or causes a claim to be submitted to the federal government that they know or should know is false. It's used as the primary vehicle for the government to recover money that's obtained or withheld by government contractors or grant recipients through misrepresentation. So there are a number of elements that are required to establish liability under the False Claims Act. There does need to be a submission of a false claim, a claim being a request for payment or property like an invoice or an obligation to pay the government. And to be false, the claim of entitlement to those funds must be incorrect or unlawful. But not all incorrect claims rise to the level of a violation of the False Claims Act. The False Claims Act must be submitted with knowledge of its falsity. So knowledge in the context of the False Claims Act means actual knowledge, reckless disregard for the truth or falsity of the claim, or deliberate indifference as to the truth or falsity of the claim. So this means that liability can be imposed not just for intentional fraud, but also where there's reckless behavior, which is closer to gross negligence or gross negligence plus. Or it can also be liability for deliberate indifference, which is basically where you stick your head in the sand like an ostrich and you're purposely ignoring red flags of potential wrongdoing that are showing up around you. And I do also want to mention that for False Claims Act to result in liability, the false statement needs to be material to the government's decision to pay, meaning it has a natural tendency to influence the decision maker. So this basically means that false or inaccurate statements that wouldn't impact the government's decision to pay the claim shouldn't result in FCA liability. So these knowledge and the materiality elements really are critical to differentiating between simple mistakes or contract breaches and an FCA violation. So FCA matters can take shape through two different routes. They can be government-initiated matters or they can be qui tam matters. Government-initiated matters typically arise out of an investigation, often by the agency Office of Inspector General or by DOJ, or they can arise through a complaint to a government whistleblower hotline. In these cases, the company or the individual being investigated usually will receive a subpoena or a civil investigative demand from a government agency. If that investigation ends up leading to litigation, the United States is the plaintiff and they pursue the FCA violation and damages and penalties. It's important to note or remember that the False Claims Act provides for recovery of treble damages plus penalties, which currently are roughly between $14,000 and $28,000 per violation. So there's significant monetary liability that can result. And then the alternative way is that the False Claims Act has a private right for a whistleblower who's called called a relator in this context to file a qui tam matter on behalf of the United States. Whistleblowers often tend to be former employees or competitors or some other individual with inside knowledge of the defendant's actions. In qui tams, the relator files the lawsuit under seal, so the defendant doesn't know about it right away and the government gets a chance to investigate the allegations. And they determine whether to intervene in the lawsuit and basically take over the case from the whistleblower. But they can also decide to decline to intervene, in which case the relator can still proceed with the case, although the government can move to dismiss it. A notable point here is that the qui tam relators are entitled to between 15 and 30% of the total damages recovered by the federal government, so they're highly motivated to come forward with allegations and file those whistleblower complaints. Okay, so moving on to examples of False Claims Act violations, we've got several different types here. So the most straightforward situation is when the government is overcharged because something in the invoice itself is incorrect. So this could be like where the contractor bills for services that weren't provided. For instance, billing for 400 hours where you only provided 40 hours of work, or where the invoice correctly reflects 40 hours of work, but it charges at the wrong rates. In this situation, on its face, the invoice is incorrect. Next, we've got the reverse false claim situation. So this is where the contractor is already in possession of money or property that the government is entitled to, and they fail to return that money or property, such as where the contractor is aware the government is overpaid, but it knowingly fails to return that overpayment. This type of case has popped up with respect to the PPP program, where somebody receives forgiveness for a PPP loan when they really weren't entitled to it. So False Claims Act liability can also arise from making false representations in conjunction with a request for a payment. In these cases, the invoice itself may be accurate. So for instance, you bill for 40 hours of work and you actually did that work, but the invoice is accompanied by a statement or a record that's false and induces the government to pay the claim. This could occur where some certification is required. It can be an express certification, for instance, that all contract requirements are met, or that all subcontractors have been fully paid. It really depends on the language of the contract and in the invoice as to what representations are actually required and being made to influences the government's payment decision. There can also be liability for implied rather than express certifications. So even if there's no written certification, courts have held that the submission of the invoice itself carries with it an implied certification that the contractor is in compliance with material conditions for payment. So this means that if the contractor knows its performance has violated statutory, regulatory, or contractual requirements in some way, but it submits an invoice regardless, the invoice submission can constitute a false claim. Next, we've got the fraudulent inducement theory of liability. So this is where the contractor induces the government to award a contract through false statements or fraudulent conduct. For instance, fraudulent inducement may exist where a company misrepresents its small business or socioeconomic status, or where it makes material misrepresentations in its proposal. And when that occurs, all claims for payment submitted to the government under the contract are considered false because they're tainted by that initial misrepresentation that was used to obtain the contract. And then finally, we've got conspiracy here. So this could occur when there's conspiracy between owners of, for instance, two companies who are teaming together to falsely represent one company as a small business and then have it pass through the majority of the work and revenues to the other company. Basically, any sort of conspiratorial action that would meet any of these other circumstances, that can also be a basis for liability. All right, moving on. So turning to DOJ's annual report, on January 15th, DOJ released its annual fraud statistics report, which provides information about settlements and judgments obtained under the FCA during the prior fiscal year, 2024, which ended on September 30th of last year. So during this period, the government recovered over $2.9 billion. This represents a 4.8% increase compared to the prior fiscal year. And it's generally in line with recoveries that we've seen going back a number of years, except for fiscal year 2021, which had a much higher recovery of roughly $5.7 billion. That was in large part due to a $2.8 billion settlement related to false representations in marketing opioid drugs. So that's kind of the reason that we had that outlier there. Okay, we can go on.
All right. So just a few tidbits from the report that we're going to sort of extrapolate on a bit. So in generally speaking, new FCA matters are continuing to increase, and that has been something we've seen in particular the last 2 years. So in fiscal year 2023, so ending September 30th, 2023, there were 1,218 new FCA matters initiated. That means a DOJ investigation was opened or a whistleblower qui tam suit was filed. That was a record high at the time. And it was the only time in history at that point that that new matters had exceeded 1,000. But then in fiscal year 2024, so ended September 30th, 2024, that number grew significantly to 1,402 new matters, and that was driven largely by new matters filed by relators, whistleblowers. It was a 37% increase compared to the prior year, whereas there were 423 new matters initiated by the government, which is a 16% decrease. The qui tam matters is the highest number in history. The next highest is significantly lower, 757 in 2013. And the number of new qui tam suits has increased each year since 2021. So what are the key takeaways from that? Whistleblowers, as Jackie mentioned, have a huge incentive to file suits, whether they are accurate or not, speculative or not. As Jackie mentioned, they can recover between 15 and 30% of the government's financial recovery, plus their attorney's fees. So you'll hear during this webinar that there have been settlements in the neighborhood of $365 million over the last 2 years. Well, 15% of $365 million is, I'm not a math wizard, but over $50 million. That's a huge incentive for a disgruntled employee, a competitor, someone, a vendor, to blow the whistle on information that they don't have a lot of insider knowledge on. And so we're going to continue to see increases in qui tam actions over the next several years at least, particularly with regard to pandemic fraud, healthcare fraud, and procurement fraud. We're going to talk about all of those things a little bit. Given the increase in qui tam and overall matters, we're going to expect the number of settlements and judgments to increase as well. Matters are rarely resolved in the same fiscal year they are initiated. Frankly, Jackie and I have a qui tam matter right now that was initiated in 2016. Here we are 9 years later, and we haven't even gotten to trial in that matter. So it takes a very long time for a matter to initiate and then reach its full lifespan. And so we tend to see these large numbers of new matters, and then we see the resolution of those new matters 5, 6, 7 years down the road. So over the course of the next 5, 6, 7 years, we expect the overall recoveries to increase. And that, again, is driven in large part by a renewed focus from whistleblowers, or an expanded focus from whistleblowers, on qui tam matters and the False Claims Act in general. All right, next slide. So I touched on this a little bit a minute ago, but settlement and judgments remain high. In fiscal year 2023, there were 566 total settlements and judgments. That was the highest in history. We fell off just a little bit, only 8 fewer in 2024. Key takeaways from that, next slide, please. The key takeaway from that is that we're going to see at least consistent, but probably increased settlements and judgments moving forward. Newly initiated FCA matters had been somewhat consistent between 2015 and 2022. Now, there's a big difference between 768 and 963, which are the high and the low during that time frame. But generally speaking, they would fluctuate in between those numbers, and no one looked at it as a significant telltale sign of things to come. However, then there's this drastic increase in 2023, and then another significant increase in 2024. That can be reflective of uncertainty in the economy. Typically, as a litigator, anecdotally, I've seen that employee suits, and a lot of qui tam actions are employee suits tend to increase during times of economic uncertainty. There has been a lot of economic uncertainty over the last 4 years, particularly with high inflation. There were layoffs as a result of high inflation. Despite there being low unemployment for the last 4 years, there has been increases in costs incurred by everyday citizens, and that incentivizes them. How am I going to protect my family from financial uncertainty? Do I have a lawsuit against my employer? Maybe. And that's where a lot of lawsuits come from. And one of the most important things that I can recommend is to take employee complaints very, very seriously. When an employee says, even if you feel like they are wrong or they don't have the information that is necessary to make the complaint, you still investigate it, because an employee who says we're not meeting our cybersecurity requirements on our contract, they might be wrong, or there might be a sliver of truth to what they're saying. But even if they're wrong, that lawsuit might be coming. And if it's a $10 million qui tam suit, the whistleblower may be looking at a potential of up to $3 million in recovery. That's a lot of incentive to move forward against an employer who you feel who a whistleblower feels isn't listening to them. It can also be reflective of recently published qui tam successes. So the government has taken a hard line. They published the results of qui tam and government initiated settlements and judgments in FCA matters. As I mentioned, there is a settlement of 365 or so, it may have been even higher than that, $1 million in 2023. When you see those as an employee or a competitor and think, I could share in that windfall, it encourages people to file these lawsuits. And there are a lot more qui tam lawyers now than there used to be 15 years ago, individuals who are willing to take these cases hoping for a windfall. But it can also reflect abuse of the qui tam system. I was involved in a matter late last year where an individual had filed 7 separate qui tam lawsuits, and none of them had a legitimate chance of success. None of them had even a particularly accurate recitation of the facts. They had speculation, they had conclusory statements, they had theories that are not viable under the False Claims Act, and yet they filed those actions anyway, essentially because they thought genuinely or non-genuinely, ingenuinely, that they could get something out of these suits. Well, those are very, very expensive cases for government contractors to have to defend against. And so it's important to make sure your compliance is on point, that you're paying attention to the regulatory, statutory, and contractual requirements that you're facing, and make sure that you have a document or a documentary paper trail that can show that you're in compliance. As I mentioned, FCA matters take years to resolve, so we expect settlements and judgments to increase in the next 3 to 5 years and to continue to increase after that. Next slide. So one of the primary focuses of the government's FCA practice is healthcare fraud. And healthcare fraud continues to be a major driver of overall fraud recoveries, but we have started to see some reduction in overall recoveries over the last couple of years. There were 85 new matters in fiscal year 2024 compared to 95 in 2023. But 2024 saw an increase in overall qui tam matters of 370 versus 349 the year before. Total settlements and judgments for healthcare fraud totaled approximately 1.7 billion. That's 200 million less than 23, and that actually was lowest recovery since fiscal year 2009. But the key takeaway here is what is healthcare fraud? It's generally the misuse of Medicare, Medicaid, and other funds that are allocated by the government for healthcare purposes. These healthcare fraud numbers do not include procurement fraud for obtaining a healthcare contract. So let's give an example of an 8A company that wins a healthcare contract with the VA. If that healthcare contract was procured by fraud because the company is not an 8A, or maybe they're not an SDVOSB and it was an SDVOSB set aside, that wouldn't be counted in the healthcare fraud. We're really talking about Medicare and Medicaid fraud when we talk about healthcare fraud. Next slide. And there are 3 sort of large buckets that I would refer to when I talk about healthcare fraud. The first and significant focus of the government over the last couple of years has been the opioid epidemic. And there is a very large settlement of 476 million related to opioid industry False Claims Act allegations in the fiscal year. We're also talking about healthcare kickbacks in the Stark Law, and I call them healthcare kickbacks because there is a movement in the government contracting space to allege False Claims Act violations based on alleged kickbacks. But frequently, relators, they usually don't come from the government. They're typically from relators. They have a very significant misunderstanding about the kickback statutes that apply to government contracting and the kickback statutes that apply to healthcare. So when we talk about kickbacks and Stark Law, there are numerous settlements throughout the year. You probably see multiple a month. We're talking about doctors who may receive some sort of incentive for referring patients to a specific healthcare company, or providing incentives to patients to use a doctor, a specific doctor, and those doctors receive Medicare or Medicaid funding. And then obviously we're talking about Medicare and Medicaid fraud, and there are a lot of ways that companies can violate Medicare and Medicaid regulations. It can be through disclosures of relationships. It can be through pricing of pharmaceuticals or healthcare. It can be through misrepresentations about the healthcare someone actually received. So we call that upcharging sometimes, when a person is receiving treatment for a specific ailment and either the doctor gives treatment that is not called for that ailment, or they refer to the treatment they received as something that's more expensive in order to increase the overall cost to the patient and ultimately to the government. All right, next slide. So there was a post-report, reporting period, I should say, settlement of $450 million in October, related to allegations of paying copays instead of how copays were paid and steadily raising drug prices in out of proportion with the relevant Medicare regulations. And there is an allegation of a conspiracy with other drug manufacturers to increase drug prices, but also to receive kickbacks. So we've got healthcare companies that are receiving benefits from each other in order to ensure that copays and drug prices stay high. That's one example. There's hundreds of examples of healthcare fraud settlements over the course of a year. So we're giving you a very high level explanation here. Next slide. Now, some key takeaways from the healthcare numbers. There's a drop in healthcare fraud recoveries in fiscal 24, as I mentioned, and there has been a slow decrease in new healthcare matters over the last several years. Part of that is because healthcare companies are cleaning up some of their regulatory compliance, because these qui tam matters and DOJ filings are well published. They show that practices may not have been, at least in the government's mind, fully compliant. And so healthcare companies are doing a better job of cleaning that up. But we should also expect a slow decline in the number and value of healthcare fraud recoveries moving forward, unless we come out with a significant change to Medicare or Medicaid regulations over the next few years. All right, next slide.
Okay, so turning now to procurement fraud. The annual report does not provide specific data on procurement fraud, unlike the healthcare fraud that Matt was talking about, but DOJ's press release does show continued pursuit in this area, especially in purchases of goods and services for the military in particular. Some of the types of fraud that are highlighted by DOJ in its annual report and its press release that goes with the report involve small business set-aside fraud arising from noncompliance with contracts or regulations, and invoice inflation. So we're going to cover each of these different areas with some of the settlements that we've seen. So first, we've seen many FCA investigations and lawsuits that stem from allegations related to small business and set-aside program fraud. So what I'm talking about here, these relate to misrepresentations of a company's small business size or socioeconomic status in order to receive contracts. For instance, a purported small business may not actually be small if the business has affiliates as defined by SBA's regulations, and it fails to account for its affiliates' revenues when it's calculating its size. Or it could lose its small business status after a merger and acquisition. As an example of the latter scenario, there was a $3.9 million settlement that was announced in January of 2024, resolving allegations that after an acquisition, the contractor misrepresented its status as a woman-owned small business to obtain a DHA task order set aside for WOSBs. Here in 2017, the contractor had been awarded a multiple award IDIQ contract set aside for small businesses with the potential for task orders to be further set aside for particular socioeconomic groups. And then in December of 2018, the contractor was acquired, which allegedly caused it to lose its WOSB status. So the allegation was that in January of 2019, shortly after the acquisition, the contractor had falsely represented that it was a WOSB eligible for the task order set aside and that its SAM representations were accurate when they hadn't been updated as they were required to after the acquisition. So you really got to stay on top of the mergers and acquisitions, how your status has changed and what the requirements are under your contracts to re-represent and update for your current status. More recently, at the end of this January, DOJ announced a settlement for approximately $950,000 to resolve allegations that a contractor and its subsidiaries improperly bid on small business set-asides when it wasn't eligible due to affiliation with some other companies. The press release from DOJ noted that the contractor had received cooperation credit, which resulted in a lower settlement. So in this way, it's important to consider, how you can cooperate when you're under investigation, because it can have a substantial impact in what the final monetary settlement amounts are going to be. In this case, the company had self-reported to DOJ and took proactive steps, including engaging with the investigation and providing its employees to be available for interviews and implementing corrective measures. So small business fraud can also arise when a company misrepresents its socioeconomic status, where it's not actually owned or controlled by the proper individual. For example, that would be a woman for a WOSB or a service-disabled veteran for an SDVOSB. So there may be a woman or an service-disabled veteran who owns and controls the business on paper, but they're really just a figurehead and not really running the show. So an example of this, back in November, DOJ announced a settlement resolving allegations that executives of one company engaged female relatives and friends to serve as figurehead owners of purported small businesses so they could get set-aside contracts, but then they subcontracted substantially all of the work to the company who was leading the scheme. So to avoid these situations, small businesses need to make sure that they understand the eligibility requirements, not just be figureheads, not just have it look like they're in charge on paper. And you also need to understand methods for calculating your size, understanding who your affiliates might be, and including their revenues when you're calculating your size. I also want to point out here that DOJ has shown skepticism of mentor-protege relationships and joint ventures between large businesses and small businesses. The concern there being that the large business is managing the joint venture and performing the majority of the work, or otherwise not providing benefits to the small business protege as intended by the mentor-protege program. It's really supposed to be the small business who's in charge and performing the majority of the work, or at least 40% in the joint venture context. So mentors and proteges need to be careful not to cross the line with regard to the level and type of assistance that's being provided by the mentor to the protege. You need to make sure that the assistance that's being provided is in line with the SBA-approved mentor-protege agreement. So really stick to that. If you contemplate changes to the type of benefits or assistance that's going to be provided, then you can go to SBA and have that agreement amended. But just be aware that this is an area that DOJ is looking into.
Yeah, and I would just jump in on that point really quickly. When we say that DOJ is skeptical, that's because they flat out told us that they are skeptical of mentor protege and joint ventures in general. This isn't so much from settlements or judgments, although we've seen those as well over the last several years. DOJ attorneys just simply think that the mentor protege and joint venture programs under the SBA are vehicles for fraud. And they're essentially vehicles for larger businesses to keep set-aside contracts that they may have qualified for previously. One thing that I would point out is that was sort of the point of the mentor protege and joint venture programs that the SBA created. It's to give runways for small businesses that couldn't perform the contracts themselves. And so they have performance of work requirements. And so long as the joint venture parties or the mentor and protege are paying close attention to the performance of work requirements, ensuring compliance with the regulations, asking questions where needed, there shouldn't be a problem, an FCA problem at least, with mentor protege or joint venture agreements. But it will attract more scrutiny from the government for sure, and from whistleblowers. And many times there is a misunderstanding on the plaintiff's side in an FCA matter about how mentor protege and joint ventures work. And so if you are involved in a small business or set aside joint venture, it is really important that you are very careful about your compliance and documentation of your compliance with the applicable regulations in order to set your best foot forward if a whistleblower complaint or investigation arises.
Thanks, Matt. So the next major area of focus of DOJ that we want to talk about is where this contractual and regulatory noncompliance, where the contractor submits an invoice despite its noncompliance with certain requirements. So many of these cases involve the contractor seeking payment despite providing products or services that don't comply with the contract requirements. So as an example here, contractor that manufactures ships for the United States agreed to pay $800,000 to resolve allegations that it knowingly installed valves on ship holes when it knew the valves had not met testing specifications to be deemed military grade. So, they're basically breaching the performance work requirements that are there, and still seeking payment despite their knowledge that they're non-compliant. The products or services are non-compliant. So DOJ has also focused on contract non-compliance as it relates to small business requirements, touching on, going back to the last slide, including failure to comply with the requirement that the small business prime contractor perform a certain percentage of the work itself through limitations on subcontracting and performance work requirements versus subcontracting to non-similarly situated entities. So here, like we talked about, like Matt was talking about, DOJ is concerned with the small business essentially acting as a sham or a pass-through entity, where a large or otherwise ineligible business ends up doing the majority of the work and getting the associated payment when it's supposed to be going to the small business. Another area of focus here is cybersecurity non-compliance. So I'll talk about this on another slide in a few minutes, but there has been a heavy focus on this, and we expect that to pick up even further, especially with DoD's CMMC rule going into effect last December. Those CMMC requirements are expected to start entering defense contracts around mid-2025. Contractors will have to affirm their level of compliance with CMMC, so seeking payment despite misrepresentations or a failure to comply with those requirements could be a basis for False Claims Act liability into the future. There are also a couple other potential bases for liability due to new contractual requirements and representations that may be on the horizon that I wanted to touch on here briefly. The first is that there could be increased FCA enforcement related to organizational conflicts of interest, OCIs. So in January, the government published a proposed rule on OCIs, touches on a lot of different areas about OCIs, seeking to revise the FAR to update definitions and guidance related to OCIs and provide examples of potential OCIs. It also provides for provides solicitation provisions and contract clauses to be used to avoid or mitigate OCIs, and touches on other areas as well. But for our purposes here, it's those new solicitation and contract clauses that are worth noting. So they would require offerers and contractors to disclose information about OCIs and make affirmative representations about their disclosures. And it would also make any government-approved mitigation plan for identified OCIs to become contractually binding. They'd be part of that contract. So that means that misrepresentations about OCIs or knowing failures to comply with the mitigation plans could then lead to FCA liability. So this is a proposed rule. We'll have to see what changes are made. It's going to take a while before a final rule to be published, but this is definitely something that contractors should be keeping an eye on. The second area here that I want to touch on is the potential for increased enforcement related to DEI programs. So probably most of you are aware, President Trump has issued several executive orders addressing DEI that required termination of all contracts or grants that included DEI policies or preference of programs. And it terminated federal government employee positions or organizations related to DEI efforts, directed the Attorney General to prosecute private sector entities that maintain DEI programs, and for our purposes here, it required certification by federal contractors that they don't operate any illegal DEI programs. So the certification requirement is something to keep an eye on because it creates that potential basis for FCA liability if contractors maintain the so-called illegal DEI programs, but they certify they don't have any such programs in order to be awarded a contract. Lawsuits have been filed that are challenging the EOs, and on February 21st, a federal district court did issue a preliminary injunction enjoining aspects of the executive orders, including this certification requirement. Basically, the court found, among other things, that they failed to adequately advise contractors on what constitutes an illegal DEI program. So there's not enough guidance out there for contractors to really understand what they're certifying to. So this is something that, the litigation has to play out. We'll have to see what happens here, but it is something that may be out there on the horizon as well.
And before we move on, I want to hop back to the OCI issue and a tangential issue with that. I'm sure that most of you have seen that DOJ is encouraging a significant portion of the federal workforce to resign, or there will be layoffs in the future. Where are those people going to go when they leave the government? They're going to go into the private sector, and a lot of them are going to work for government contractors. And so when we think about OCIs, and relationships with former procurement officials who may have left their positions with the government, there's a cooling off period before an individual who used to work for in the procurement office in particular, or who was an official at an agency, can be involved in procurements that relate to that same office. And so it's really important to think about your hires. If you're hiring someone from the government who's been at the government recently, you're going to want to make sure that you're in compliance with the cooling off period for those individuals, firewall those individuals from procurements where they could, where an OCI or a cooling off violation could occur, because arguably those could create False Claims Act violations as well.
Okay, so the last major area where we're covering some examples here relate to contractors inflating their invoices in some way, this resulting in overcharging to the government. So the first example that we have here dates back to a settlement from mid-2023 for $377.5 million. This resolved allegations that the contractor improperly allocated indirect costs associated with its commercial and international business to its government contractors, that it failed to disclose its methods for accounting for these costs, and as a result, it was reimbursed for commercial costs that provided no benefit to the government. This is a really large recovery, and it shows how failure to comply with cost accounting standards and what can be allocated for indirect costs to government contracts and what can't, how non-compliance with those can trigger liability. Next, DOJ reported a settlement of $18.4 million to resolve allegations that the contractor billed for time not worked. This is basically a straightforward example of contractor employees recording hours on their timesheets that they didn't work, which the government ended up paying. In December, DOJ reported that a contractor paid $55 million after a trial judgment where the contractor was found liable for misrepresenting commercial sales practices to GSA in relation to its multiple award schedule contract, which led the government to pay higher prices than it would have had it known of the contractor's actual commercial pricing practices. In addition to making false statements about those commercial sales practices during its initial contract negotiations when it first got its schedule, and also falsely asserting its disclosures of commercial sales practices that they were accurate over the next several years, the contractor was also found to have violated the price reduction clause, which would have entitled the government to discounts. So this litigation goes back, Matt was talking about how this can extend for a really long time. The litigation goes back like over a decade. The case is also notable because the judgment initially was entered in 2023 for only $1.6 million. After the judgment was entered, though, the government moved to amend the judgment, claiming that the court had miscalculated the damages. It took almost a year, but the court agreed that it had erred in calculating both actual damages and penalties. Since the penalty needed to be imposed for each false claim, the number of false claims was increased by the thousands, going back and looking at the calculations, and that ultimately increased the judgment to roughly $53 million, and so that 1.6 million. Those the damages calculations can be pretty complex. It took a while here to get that straightened out. Lastly, here we have an example where two contractors that were owned by the same parent company agreed to pay $70 million to resolve allegations that they knowingly entered an improper cost plus percentage of cost subcontract, which caused the Navy to pay inflated costs for parts to repair aircraft. Under the subcontract at issue here, the prime agreed to purchase parts from the sub at the cost that the sub paid other suppliers for those parts, plus a fixed 32% markup. These types of cost plus percentage of cost contracts are prohibited because they give suppliers an incentive to drive up costs to increase the profit. The prime submitted the cost vouchers to the Navy for reimbursement of the amounts it paid to the sub without disclosing that it was using this improper cost plus percentage of cost nature of the subcontract, which the Navy alleged rendered the vouchers fraudulent. So there's a variety of different ways that you can end up overcharging the government. It's in each of these cases, there's some element, at least allegedly, of this knowing element. So it's not just the overcharging the government and having the invoices be inflated, but that this was done in a at least reckless manner, if not with deliberate intention, deliberate indifference or intentionality. Okay, so lastly, on the procurement fraud side, DOJ's press release accompanying its annual report highlighted a settlement that was reached in October 2024. So this was shortly after the end of the 2024 fiscal year. It included it since this is a major settlement. The $428 million settlement is the second largest procurement fraud recovery in history. This settlement resolved a key TAM lawsuit filed by a former employee of the contractor at issue, and that relator ultimately received $4.2 million as part of the settlement. It involved allegations that the contractor failed to provide truthful cost and pricing data during negotiations on many contracts between 2009 and 2020 in violation of the Truth in Negotiations Act. As part of the settlement, the contractor admitted that it failed to disclose required cost or pricing data regarding its labor and material costs to supply weapon systems to DoD. And by misrepresenting those costs during negotiation, it ended up overcharging the government, and it received profits in excess of its negotiated profit rates. It also admitted that it billed the same cost twice on a DoD contract, which resulted in the contractor receiving more than the negotiated price of the contract. So if you just think about like all of these different areas where you're making representations to the government, you have to provide them with information. There's just a lot of different avenues for there to be express or implied certifications where you're providing information. If it's not accurate, you need to clear that up with the government and not have any falsity by omission, by failing to clarify. So yeah, a lot of different avenues for liability on the procurement fraud side.
And so just to piggyback a little on those numbers that Jackie mentioned, so we've got this $428 million settlement in October, which is after the end of the fiscal year. We had mentioned one in healthcare, which was also over 450 million. So right there, we're talking about 875 million in settlements that happened in the last 3 months of calendar 2024 that are going to be counted in next year's numbers. The average FCA settlement in fiscal year 24 was a little less than $6 million. So, approximately 550 settlements across approximately $3 billion in recoveries. We are going to be way ahead of that average by the time we get to September 30th, 2025 at the end of this fiscal year. So just extrapolating from those two very large settlements, we could see recoveries well in excess of $3 billion in fiscal 2025. But we can jump ahead to the next slide and talk a little bit about pandemic fraud. Obviously, everyone is familiar with the COVID-19 pandemic. We probably all have PTSD from it. Well, the PPP loan, EIDL loan, and there were various other pandemic relief programs that were designed originally to help small businesses survive the pandemic, have created a lot of False Claims Act litigation and investigation over the last couple of years. Things obviously happened in 2020, 2021, 2022 because there was fraud that occurred that was so blatant that it was easily caught. But as the government looks through PPP loans in particular, they're discovering additional fraud. Fiscal year 2024 saw 250 settlements and judgments totaling 250 million, or approximately 1 million per settlement. in pandemic relief and PPP fraud claims. But I will say pandemic fraud data is not always formally pursued, or I should say pandemic fraud data doesn't always reflect the scope of the investigation. In particular, there are some areas of the country, some district offices of DOJ that have a lot of PPP loan cases, and they're trying to get them resolved on the front end, particularly where there's not a lot of evidence of intentional or reckless fraud. What we're talking about is people who misunderstood regulations that were changing rapidly over the course of a short period of time. And ultimately, they may have received multiple PPP loans in a single draw because they didn't understand the program. DOJ generally will work with those companies that are cooperating with the investigation and trying to get those claims resolved and repay funds. But generally, those PPP loans are not being repaid at 100%. They're being paid at multiples of the amount received. So if you've got a $400,000 PPP loan that is allegedly procured by fraud, you're looking at settlements somewhere between 400 and 800,000 for that single loan. Some, if there's more indication of fraud, then it's going to be more in the neighborhood of 800 to 1.2 million. So I focus on that because there are a lot of ways to screw up your pandemic relief applications, certifications, and forgiveness applications. And it's important that you don't just forget that you got that PPP loan at this point. You need to keep your paper trail, maintain knowledge about why you applied, what you did with the money as long as possible, because FCA cases have a very long shelf life, as we've talked about a couple of times, and you want to ensure that you still have access to information to defend against a claim if it comes up in the future. All right, next slide. An exact number of PPP loan fraud recovery is not provided in the report, but there was some indication that pandemic-related settlements and judgments decreased slightly from fiscal year 2023. I think that makes sense. It's a short-term program that no longer exists. PPP loans you can't get them anymore. I would expect a continued slow decline in PPP fraud matters and recoveries. Same with EIDL and other pandemic relief programs. We will continue to see numbers and settlements that come across. However, I think as we get further away from the timeline of when those loans are available, the number of matters and the settlements and judgments will decrease.
So the last major topic that we want to cover from the annual report relates to cybersecurity fraud. So as a little bit of background, in October of 2021, DOJ created a civil cyber fraud initiative to pursue cybersecurity related fraud by government contractors and grant recipients. The initiative announced its first few settlements in 2022 and 2023, where contractors falsely represented compliance with cybersecurity requirements. And the initiative, we're just seeing it's continuing to pick up steam. That's reflected in DOJ's press release, its annual report, and just the settlements that we've been seeing since it's gotten underway. So a couple of recent settlements of note that we wanted to point out here. The first is an $11 million settlement with two consulting companies. This resolved allegations that the companies failed to meet cybersecurity requirements in a contract with the state of New York, which was funded by a federal grant. The contract was intended to ensure a secure online environment for New York residents to apply for federal rental assistance during the pandemic. The companies were required to perform cybersecurity testing of the online site used to house the applicant's information before it was launched to the public, but the companies admitted that they failed to complete the required testing, and the site was shut down within 12 hours after applicant information was compromised. So a clear failure to comply with the requirements, but then they're submitting claims anyways. The second, announced in October 2024, is a $1.25 million settlement resolving allegations that a university failed to meet cybersecurity requirements across 15 different contracts and subcontracts with DoD and NASA, including that it failed to meet cybersecurity controls. The university didn't adequately develop and implement plans to correct deficiencies that it had identified, and it failed to use a qualified external cloud service provider. So a lot of this relates to representations that it made about meeting these controls and addressing the deficiencies. So it's not really just that there is a deficiency, but representations related to fixing them and having the controls in place. And it's those representations that are false in conjunction with the request for payment where the liability stems from. So if we go to the next slide, the key takeaways here. So in light of the Civil Cyber Fraud Initiative, we really do expect more cybersecurity actions to be initiated in 2025 and beyond. Contractors really need to stay abreast of cybersecurity requirements in their contracts and review their internal policies to ensure they remain in compliance, and that any representations that they're making in their contracts to the government are accurate. And as I mentioned, be on the lookout for those CMMC requirements in DoD contracts later this year, as those provide another basis where you're making representations, and you need to make sure that those are accurate.
So one thing that I would mention is that cybersecurity requirements often are not express. You don't have to make an express certification in your invoice because they've become a natural part of working with the government. And so what we're talking about here is often an implied certification. When you submit that invoice, even though you're not saying word one about cybersecurity, the implication by submitting that invoice is that you are compliant with the cybersecurity requirements in your contract and any regulations that impose cybersecurity requirements. For instance, there have been cases, the original cybersecurity settlement under the FCA was, I believe, in 2018. And in that case, the allegation was that the contractor, not only did they not meet their cybersecurity requirements in their own contract, but they failed to allow the government to meet its cybersecurity obligations in the procurement of that contract. And so it's important to understand the full scope of your cybersecurity requirements, because I think that, as Jackie has kind of alluded to, this is going to be a significant focus and a real pain point for government contractors moving forward. All right, next slide. This is the last topic we're gonna talk about, and this is my pet project. So there's some interesting stuff happening with the FCA in federal courts recently. So on the last day of the fiscal year, September 30th, 2024, a judge in the Middle District of Florida entered a judgment against a relator, a qui tam relator, in a non-intervened case. And what we're talking about there is, when the whistleblower files their suit under seal, the government has a period of time to decide whether to intervene in the litigation or to decline to intervene. If they intervene, the government is going to take over and run the show. If they decline to intervene, then the relator under the FCA has the authority to proceed in the name of the government and try to get a recovery. Now, the government continues to participate in some ways, but it takes a backseat to the relator. Last fiscal year, a couple of Supreme Court cases came out related to the FCA, one called United States ex rel. Polanski versus Executive Health Resources. And in that case, Justice Thomas wrote a dissenting opinion where he questioned whether a relator, whether the statute is constitutional to allow for a relator to pursue a qui tam action in the name of the government where the government has declined to intervene. And Justices Barrett and Kavanaugh concurred that that is an issue that needs to be addressed in a future case. Well, Zafroff became the future case in September 2024, and that matter is currently before the 11th Circuit for briefing. Just last week, or earlier this week, on the less than a week ago, on the 21st, in another Supreme Court case, Justice Kavanaugh again raised the constitutionality issue as to whether a relator who in a case where the government has declined to intervene has the authority to pursue the case in the name of the government. What that would mean if the government or if the Supreme Court decides that the statute is unconstitutional is that all qui tam cases where the government has declined to intervene would need to be dismissed. So let's take a look at one last slide. Again, it's currently being briefed in the 11th Circuit. It probably won't be complete. Briefing won't be complete until April or May of this year. And then we're obviously going to have a period of time where the 11th Circuit has to hear that case orally and then make a decision. That could be up to a year. So maybe we're looking at the middle of 2026. And then I think for sure that case is going to the Supreme Court. And so I think we may have a decision by 2027, maybe June 2027, as to whether the False Claims Act is constitutional. I will say no federal court until Zafarov had ever determined the Ketan provisions are unconstitutional, but high-ranking DOJ officials, including former Attorney General Bill Barr, had uh, opined that the FCA was unconstitutional at various times. However, most recently during her confirmation hearing, current Attorney General Pam Bondi testified that it is her intention that the Department of Justice will defend the constitutionality of the FCA. All right, last slide. Thank you all very much. We just went over by about 15 seconds of our hour. We are available with questions. If you have any, you can reach out to me or to Jackie. Our contact information is on the screen. And if you have any questions about specific matters that affect you, we'd love to talk it out with you. But other than that, thank you so much for joining us. We'll see you in 12 months at our next annual review, where we'll probably be talking about more than $2.9 billion in recovery. But thank you, and we look forward to seeing you again soon.
Thanks, everybody.